Good morning. I'm Kerri Nice. I'm Assistant Director at the Division of Personnel. Can you guys hear me? Yes. Okay. I'm the Assistant Director at the Division of Personnel of the Employee Relations section. For any of you that may not be familiar with Employee Relations, Employee Relations was designed to provide technical guidance and advise employees and state agencies regarding a full range of HR topics such as FMLA, ADA, legislative rules, and personnel policies. DOP was invited here today to briefly discuss with you an employer's obligation and right to implement corrective action to deal with issues in the workplace. Corrective action is a term that is used anytime an action is taken to either correct a problem, address performance issues, or improve employee performance, and can include a wide variety of different actions such as policy implementation, procedures, additional training or initial training, and up to disciplinary action. The information that we'll cover here today is intended to be used as technical guidance with the understanding that the Division of Personnel doesn't engage in or render legal services or advice. If a legal opinion or advice is required, we suggest that you obtain the services of an attorney. Because every case is unique and different, we encourage you to confer with your agency's legal counsel prior to changing the conditions of an employee's employment, which can include things such as moving a department, moving a physical location, changing work hours, conditions of employment, or implementing any kind of disciplinary action. All right, John, which one do I press? This one. Okay, there we go. The retaliation and discrimination language in state and federal code often brings employers the impression that employees engaging in a protected activity are immune from disciplinary or corrective action. However, an employer's right to implement corrective action in the workplace does not cease simply because an employee is engaged in a protected activity such as filing a grievance or a workers' compensation claim. In fact, the West Virginia Code speaks to the most severe form of disciplinary action and recognizes there are times and circumstances when action needs to be taken. In part, Section 23.5A3 reads in part, it shall be discriminatory practice to terminate an injured employee while an injured employee is off work due to compensable injury and is receiving or is eligible to receive temporary total disability benefits unless the injured employee has committed a separate dischargeable offense. A separate dischargeable offense shall mean misconduct by the injured employee wholly unrelated to the injury or the absences from work resulting from the injury or the aggregation of absences due to the injury with any other absences. What do we consider a separate offense warranting disciplinary or warranting some kind of corrective action? This could be corrective action which occurred prior to the accident or injury. For an example, if you had some kind of a predetermination already scheduled, depending on the employee's availability, you could continue to have that predetermination. If you have disciplinary action or some kind of corrective action that was already scheduled following the predetermination, depending on the availability, you may proceed with implementing those kinds of actions. Or if there has been an investigation of some sort that has been previously implemented or initiated, you can continue with that investigation and wait for the employee's participation and input when they are able to return. It may also include violations, misconduct, or some kind of unacceptable performance that occurred prior to the injury, but no action has yet been initiated. In this scenario, the timing is very important, because if there has been unlike the one an action that's been previously scheduled, if the time between when the problem occurred and when the employer tries to initiate corrective action is too great, it can give the appearance of retaliation for filing a claim. However, unless there are mitigating circumstances which support taking action following some kind of injury or illness. A separate offense could also include violations, misconduct, or something that contributed to the incident, to the injury. For example, the state code reads wholly unrelated. However, provided that your discipline and your corrective actions are consistently applied, this can actually include any kind of violation or misconduct or performance issue that contributed to the accident. For example, an employee who may be disciplined due to, they say they were injured on the job due to sleeping. The discipline would be implemented for the policy violation of negligent conduct of sleeping on the job, but not being disciplined for having an injury. So it can be any even misconduct that is related or contributed to the accident itself. Finally, it can be any kind of policy violation, misconduct, or unacceptable performance following the incident. Examples of this could be failing to turn in the proper medical documentation to support the need for the leave. It also may be failing to follow the agency's call-in procedures if it's an intermittent need for leave, or even refusal to return to work following a medical release. When determining the appropriate level of corrective action, an employer must consider the specific circumstances, including any mitigating or aggravating factors. The nature of the incident, is there actually an alleged violation or misconduct? Is the process for addressing performance failures and misconduct something that has been established and is consistent in the past practice? The timeliness of the action, and is the action that's being considered, is it based on the seriousness of the offense? The goal of corrective action and disciplinary action is to correct the unacceptable performance, not to discipline the employee. So let's look at a couple grievances. The first one deals with attendance, and attendance is one of my favorite subjects. It's come to my attention that illness and attendance issues, or attendance, illness, and injury often go hand in hand. Some of the absences occur following illness or injury, which is a given. But some of the illnesses and injuries follow excessive absenteeism. I think Tom referred to this as the mailbox money. Okay, so the first grievance, and I'm afraid I'm going to have to read directly from this because I can't remember all of the grievance details. Okay, respondent testified the grievant had a history of excessive absenteeism been ongoing since 2001. However, they did not take action until February 2001 when the absences became too much of a problem to ignore. This is probably a scenario we're all familiar with. In May 2001, the grievance employee performance appraisal, or EPA, documented multiple verbal warnings for continued absenteeism. April 2nd, 2002, the respondent issued the grievant a written warning for absenteeism. The grievance attendance failed to improve, and between April 1st and May 10th, the grievant was absent 7 times, 4 of which were unexcused. On May 21st, 2002, the grievant sustained a workplace injury and was off until June 4th. Upon her return on June 5th, the grievant was issued a second written warning for absences which had occurred prior to the workplace injury. Following her return that day, the grievant filed a workers' compensation claim for the May 21st injury and was off until July 1st, 2002. July 2002, the grievance EPA again rated unsatisfactory attendance, and comments noted in the EPA multiple warnings and clarified the warnings were for covered absences that occurred before May 2002 on the job injury. On July 15, 2002, grievance filed a grievance claiming harassment from my supervisor while off sick due to injuries I sustained on the job. During the level 4 hearing, the grievance testified she'd filed a workers' compensation claim once in 1997, once in 2000, and the last time in May 2002. The grievant alleged harassment and retaliation by the respondent because the workers' compensation claim in May, and claimed that the discipline was excessive and improperly opposed because the absences she incurred were the result of problems sustained from the 1997 and 2000 on-the-job injuries. So, state code provides that absences due to a compensable injury may not be considered in the determination of leave misuse or for excessive absenteeism. In the grievance, the ALJ provided, this is a quote, while the grievance may still be experiencing back pain due to the on-the-job injuries, the fact remains that her claims for those injuries have been closed since 2000. Her absences are not compensable under workers' compensation, end of quote. The ALJ also provided, considering all the circumstances and the totality of the undersigned does not find the letters of warning relate to the 2002 on-the-job injury, but rather addresses the excessive absenteeism which has been ongoing since 2000. This grievance was denied because the respondent's documentation of progressive corrective action and progressive discipline was justified due to the history of excessive absenteeism and was not retaliation for the workers' compensation claim. Now, on a side note, while this employee's workers' compensation claims were closed and were not protected under the workers' compensation, it should be noted that employers need to be cognizant there are other forms of protected leave this employee may have been eligible for, such as leave under the Americans with Disability Act or under the Federal Family Medical Leave Act. So those are things that need to be investigated when you have employees with long-term, ongoing qualifying conditions. All right, our grievance number 2 is grievance versus West Virginia Department of Division of Corrections. Okay, so the grievance was dismissed shortly after returning from total temporary disability. The grievance claimed the dismissal was retaliation for filing a workers' compensation claim, and as a result of the retaliation, the grievance cited the respondent's 6-month delay in charging him with the 3 violations that led to the dismissal. This grievance was denied because the respondent was able to credibly testify that the grievance absence on workers' compensation, which lasted for 3 months, caused the delay in opposing the disciplinary action. These are the mitigating circumstances that I talked about for actions happening prior to, but aren't addressed necessarily timely. So mitigating circumstances that might delay imposing a disciplinary action. This particular grievance, and at the end of my slides and my end notes, there are all of these grievances. The full name is listed so that if you wish to later go on and read the full grievance, it's available to you. But this grievance also noted that disciplining the grievance during his compensation claim may have given the appearance of retaliation for filing a claim. However, in the end notes, I've also added another grievance where the grievance was denied because while the grievance was dismissed during the time that they were on TTD as a result of an outcome of an investigation that had been initiated prior to the accident. So humans make mistakes. Accidents happen. However, in many cases, dismissing safety protocols and taking shortcuts are the cause of the accident. This is nothing new, it's not a new phenomenon. Before eventually crashing head-on into an iceberg, the Titanic operator ignored as many as 6 iceberg warnings. Who can blame him? Someone told him the ship was unsinkable. Tom provided some statistics showing that 26% 26% of the claimants had 2 or more claims since 2017. Implementing a program of progressive corrective action is essential for addressing these repeat claims. A program of progressive corrective action establishes and documents. Employees know the performance expectations, they understand the policies and the procedures, and it shifts the responsibility for correcting the shortcomings from the employer to the employee and documents the employer's attempts to correct the performance. Progressive discipline and corrective action usually begins with a coaching or a counseling, before eventually moving on to something like followed by a verbal warning. When you do a verbal warning, it's important to remember that this is a conversation between you and the employee, and is not placed in writing. If you place it in writing and give a copy to the employee, it then becomes a written warning, and grievances have been granted for the employee because they are now written warnings rather than verbal. So when you have a verbal warning that you've issued to an employee, that should be kept in your administrator's file just for future reference, but not placed in the employee's personnel file. Following a verbal warning, you can move on to things such as a written warning. There are also additional performance expectations, and performance failures should also be noted in an employee's performance appraisal. That's another something to help support the employee knows, and the management team has made a good effort to help the employee perform and understand what is expected of them. Additional training, re-education, performance improvement plans are also tools available to help employees improve and to demonstrate the employer made a good faith effort to help the employee improve prior to initiating more severe progressive disciplinary actions, such as a suspension, unpaid suspension of 3, 5, sometimes 10 days suspensions, and then finally may result in demotion or dismissal. The steps of progressive discipline don't need to be strictly adhered to, provided that the level of discipline that is imposed is dictated by the severity of the incident or the misconduct. For example, a less severe action may be skipped over if, say, for example, it is a situation with drug and alcohol use or violence in the workplace that would dictate a more stringent form of disciplinary or corrective action. Each circumstance of each case is unique. You'll also want to review any previous disciplinary actions, corrective actions taken to assist the employee in improving, and that should help you dictate what level of progressive disciplinary action or corrective action should be implemented. The WV decision provided that discipline may be determined to be excessive when it is so clearly disproportionate to the employee's offense, displaying an abuse of discretion. However, the WV decision also provided that considerable difference is afforded in the employer's assessment of the seriousness of the conduct and the prospects for rehabilitation. Because only the employer knows how serious a misconduct may be, the discretion rests on the employer to determine the level of discipline that should be appropriate unless it's clearly disproportionate. One thing that employers should be mindful of is that any disciplinary action that's issued to an employee will be presented in any following grievance or court case. So you need to be, it's important to remember that any third party, say an ALJ or a law judge, may not be familiar with the subject matter. They may not be familiar with the industry-specific regulations. So avoid using acronyms, jargon, and be sure to include enough information in the letter that's issued to the employee to explain why the violation is serious, what policy was actually violated, policy or federal regulation of some kind was what was violated, and any kind of management's intervention efforts prior to the disciplinary action being taken. This will help support your case in a grievance hearing. The due process clause of the West Virginia Constitution requires procedural safeguards against state action which affects liberty or property interest rights of state classified employees. What that means is statutory entitlements provide classified employees due process at any time that a disciplinary action is being considered that will affect their pay. These include suspension, demotion, dismissal, anytime they're being considered. Exempt employees, truly exempt employees, are not entitled to due process rights. The due process hearing is often referred to as a predetermination hearing. Gives the employee the opportunity to provide a defense as to why they feel like a disciplinary action isn't appropriate. Requirements for due process include the employee must be given notice of the contemplated action. They must be given the specific charges, dates or approximate dates. They must be given an opportunity to provide and offer reasons why they feel like the action is not appropriate. This can be done either telephonically or in person, depending on the employee's availability. A short predetermination conference of under 15 minutes can be held. I would avoid holding predetermination conferences while the employees are out. That decision will need to be based on the type of injury. If the medications they're taking, if the condition has caused their brain fog or whatnot, so that they're not able to defend themselves appropriately, that should be avoided until they return to work. So you can hold these predeterminations in person or telephonically, and the employee also has a right to a representative anytime that there's a meeting going to be held where it may result in some kind of disciplinary action. So a representative can be anyone other than their direct supervisor. So it could be their mom, an attorney, a friend, as long as it's not their direct supervisor. And a reasonable time should be given to obtain those. There's no actual time period stated. How long needs to be given prior to notice that a predetermination is going to be held and when it takes place. So you could notify an employee an hour ahead of time and hold it later, but enough time for them to prepare any documentation, collect any records, any witnesses, and if necessary, time permitted for them to get the representation of their choice. Following the predetermination conference, employers should remove themselves from the meeting or completely convene the meeting to determine if corrective action or disciplinary action is appropriate. If disciplinary action is issued, the employee must be notified in writing prior to the effective date of the action. 3 days is the notification period for suspension. 15 days prior to the effective date is the date for demotions or dismissals. If the disciplinary action for employees being suspended, demoted, or dismissed, they have the right to face their accuser through the grievance procedure rights. The information regarding their grievance rights must also be included in the letter provided to the employee. There are sample letters on the DOP website for practically every scenario that you come across. Those are actually open to the public. Anyone can access them, even if you're not a DOP covered agency. And they're samples, so they need to be modified to fit your particular situation. Finally, the DOP has resources available. The Employee Relations has authored several resources for supervisors, including the sample letters previously mentioned. We also have documents and guides such as the Supervisor's Guide to Progressive and Disciplinary Action. There's a Supervisor's Guide to Attendance Management, a guide to the functional capacity evaluation, and recently we've updated the return to work guide following illness or injury. Now, this is a return to work guide that isn't specific to workers' compensation. However, it is referenced in there because in a workers' compensation type situation, you will need to coordinate with the workers' compensation within INCOVA to determine the correct return to work. And if INCOVA would like to review our document and provide me any input, I'd be happy to send it to you to review. Let's see. DOP's Organization for Human Resource Development section. They also have several trainings available, including managing in the law, workplace safety, discipline and documentation, implementing discipline, getting your bosses support, because sometimes we have trouble getting our bosses to back us up on things we'd like to do, navigating difficult conversations, and many more. You can find those listed on the OHRD's training website. There's also one that I like very much, and it is the Beginner's Guide to Due Process, because covered employees have the right to due process, and if those due process rights are violated, it's the simplest way in the world to lose grievance. So it is very short, 15-minute blast. I think I've taken it 15 times because I enjoy it so much, so I encourage you to take it. So in summary, employers have the right and the obligation to address and take corrective action in the workplace. When doing so, it's important to have written directives and policies, establish personnel practices, and apply them consistently. Document your efforts and consider the specific circumstances surrounding any incident or accident. And also consult with your legal counsel when determining the appropriate course of action. Finally, the only thing that I have left is to remind you that if it's not documented, it wasn't done. If you guys have any questions, Laura Mann and Brian Holmes are two of my personnel specialists within my unit. You're welcome to call any one of us or email dopemployeerelations@westvirginia.gov. We're happy to provide you some technical guidance. Now, DOP, the guidance that we provide are for DOP covered agencies under our legislative rule, our administrative rule, and our policies. So for agencies that are not covered under DOP, the guidance we can provide is somewhat limited. However, if you have any questions that you'd like to go over, you're welcome to give us a call. We also can review letters prior to being issued to, like I said, because sometimes you don't realize that you're using jargon that is so common to you that a layperson or third party may not understand, so we can help identify those areas to make sure that your letters and your performance improvement plans and such are clear and accurate. That is all that I have. Is there any questions?
I have one. When you have an employee that's on workers' comp and they get a clearance from the physician to return to work, but they don't return to work because they're appealing their claim denials, how long do you have to entertain that before you can terminate your job again? Or do you have to just let it play out?
It would really depend. If it seems like it's going to be a reasonable amount of time when you're going to get an answer from a medical professional saying whether or not they actually can return or their claim is going to be reopened. I don't know a lot about the workers' compensation process, but if they fail to return after they've been medically released, then they can be separated for job abandonment or failure to return from a leave of absence.
Well, I have one that's been gone a year. I mean, he's on like his fifth appeal.
Yeah.
Okay, that's what I'm thinking.
Yeah, that's grounds for termination.
Kerri, I have a question.
I'm sorry.
Do you have any advice on handling a situation where, say you have an employee that's been warned multiple times to where eye protection when they're weedy. And they end up having an eye injury while they're weedy, and they're off on workers' comp. As far as that discipline can still go through, even though, I mean, it is really directly related to the injury, but they have been repeatedly done before and documented that. That is an appropriate disciplinary process, even though the comp claim has been filed.
Absolutely, absolutely. If you
Seems to be a
have-
lot of confusion about that.
Provided it has been consistent and that everyone who's not wearing their eye protection is receiving written warnings, coachings, what have you, it's, you know, consistently applied across all of the employees, it's been documented, they've been warned, then that will completely, I mean, it supports the disciplinary action, even though a claim is involved. Yeah, because they're being disciplined for failing to continually follow the policy, not disciplined for having an accident.
Just a lot of the agencies I've talked to felt like once that comp claim's filed, hands off, you know, and part of why I wanted you to come is to let them know that there are options in how to deal with that situation.
Definitely, and they have to be dealt with because issues are contagious. If you have one who's violating the policy, it's not gonna be long before you have 2 or 3 or 4, and when you try to deal with somebody, they're gonna say, well, you didn't do it for Tom. So, yes, they need to be addressed and addressed consistently, and yes, that would definitely, if you have the documentation to support it, definitely be that would be the next step. Okay, like I said, if you have any questions following the presentation, you're welcome to give any one of us a call, and we're happy to help you.